Can everybody hear me all right?
Yes, sir. You are audible, very much audible.
Thank you very much, ma'am. Ganti sir, can you hear me?
Yeah, I can hear you.
Okay, thank you, sir. Thank you, sir. So good afternoon. Good afternoon, all the participants. Thank you for joining us for this roundtable discussion. We thank you for your time. We would be glad to have your views on board. So today we have Ravi, Prakash, Ganti sir here with us to take up this discussion on the recent IBBI discussion paper dated 15th of February 2022. The subject is very important. It is about the engagement and appointment of professionals in a corporate insolvency resolution process. There are several issues around that subject which have been highlighted in the DC orders which have been passed by IBBI. So I'll not take much of time. We have sir will take us through the entire discussion paper, and sir shall also take up different issues in it. I'll just take 2 minutes to briefly introduce you, sir. Thank you. Okay.
Not required.
Sir, just
not important. Let us focus on.
Okay, I'll just take 1 minute. Just 1 minute. Okay, so Ganti sir is an insolvency professional and of repute, as you know. Apart from that, sir is also a director at Resolve International Private Limited. In terms of the different positions, sir has held illustrious positions in several big organizations. Okay, I'll state 2 of them. Sir has been director at Messrs. Aquarius Business Solutions Private Limited and Universe India Limited. Sir has also been deputy general manager at SI Group India Limited and a senior manager at Hyderabad Engineering Industries. In terms of qualification, sir is an engineer from IIT Kharagpur. Sir is also an MBA in finance from XLRI Jamshedpur, and sir believes in adding to his knowledge, and sir believes that life is about adding knowledge and skills. So sir is currently also pursuing LLB from very famous Padma Shri Dr. D.Y. Patil College of Law. As an insolvency professional, sir has discharged many insolvency assignments, and sir, apart from that, sir has also mentored and advised several IPs in their assignments. In terms of association with us, sir is not just our insolvency professional. Sir has also been guiding us. Sir has been taking lectures on different subjects for the roundtable, for the workshops, or the PREC that we conduct. Sir, I know I've taken a little more, but I would request you to start the session. Sir, over to you.
Yeah, thank you, Nitin. Good afternoon to everybody. We have 2 options today. In case everybody has already read the discussion paper, then we will straight away go to the receiving the views of participants. But in case you feel that a small recapitulation is required, I can do that too. So please let me know, should we go straight away to what is the proposed regulation and discuss that? Or do you want a small, yes, very brief background?
Yes, a small recapitulation, sir, would be that.
Okay, fine, but it will be brief because our focus should be on the actual regulation.
Okay. Sir, very good afternoon, and sorry to interrupt you.
Yes.
But before you commence this, I have one personal small query which I would like to get it resolved from such a legendary person, Ravi sir. Kindly help me. Can I go ahead, sir?
No, if it is related to the topic at hand, we will discuss it. If it is different, then I am there till at the end. So we will do it after.
Sir, that is bit connected with this only. So can I ask, sir, actually?
Okay,
I have
fine. Go ahead.
Actually, there is a case in which an IPE, one of the
Okay. You are getting into case specifics. We will take it up during the course. There is enough time. We have more than an hour. Okay, don't worry. Definitely, we will address your query. You can ask at that time.
Thank you.
Right. So this is what we are talking about today. Okay. The engagement and appointment of professionals in a CIRP. Basically, we are this roundtable has been organized to ascertain feedback, comments, suggestions, clarifications, whatever, from IPs with respect to the proposed amendment to Regulation 27 by inserting sub-regulation 5. So I will very, very quickly run through some of the highlights in the discussion paper, okay, at the background and the observations made therein. Okay. Right. So what is the objective of this proposed amendment? It is to streamline the process of engagement of professionals by IPs, to make it more transparent and robust. Okay, these are the two, the thread you will see as we go along, that the idea is to make it more transparent and a more robust process, in the sense that it is more accountable and more reasoned in the way it is done. Okay, backgrounds. I have just culled up what I thought were the major points from the discussion paper. So first is the reference to section 20 and section 25. Both of these respectively refer to the power of the IRP or RP to appoint accountants, legal or other professional. Now this is the language of the code: accountants, legal or other professionals. For what purpose? In both cases, it is to protect and preserve the value and manage the operations of the corporate data. Now, each of this, I have tried to highlight those which are important words, because they will impact when we start discussing the proposed regulation. Now, this power has been conferred for running of the CD's business and is linked only to duties relating to managing the business of the CD. Now, once such words are used, what is by implication is that it doesn't have much to do with the CIRP process, which is distinct from the managing the business of the CD. Now, that's by implication. Okay. Reference is made to Regulation 27 as it exists today, which enables the appointment of the professionals. For what purpose? Again, to assist in the duties of the RP. The condition is that these services are required and they are not available with the CD. Okay. So it's basically focused on the business side of the corporate data. A reference has been made to the IBC Bill 2015 before it became the Act of IBC 2016. In the bill as initially drafted and put up to the Joint Committee of Parliament, the phrasing of section 20 and 25, which we had seen there, was appoint accountants, lawyers, and other advisors. Now that other advisors, the word advisors had been replaced with professionals. Now this is considered to be a major and important variation from what was originally proposed. Advisor is a very, let's say, broad term, whereas professional is considered to be having a very, very specific meaning. When we go through the paper, we will understand what it is being hinted at here. The cost of throughout this discussion paper, a couple of threads that are apparent. One is the cost factor. That cost should be the minimum possible. There should be a need, and it should be done in a transparent manner. So there is an observation made in the paper that the mandatory requirement for an RP is that whatever be the cost incurred, the CIRP as a whole is conducted at a reasonable cost. Now, the paper has also made certain observations, picking up from market practices, whatever data the board has received, judgments or orders of adjudicating authority, etc., and also from the orders of the disciplinary committee. So one of the first observations made is related to avoidance transaction and the appointment of largely chartered accountants for as transaction or forensic auditor. Now we all know that these words, transaction audit or forensic audit, are not used anywhere in the code or regulation. They are more of a market practice. The observation made in the paper is that though these are chartered accountants who are otherwise regulated professionals, but in their assignment as transaction or forensic auditor, they are working in an unregulated framework and have no accountability. Now, these words are used in the paper, okay, and they have impact. They are important to keep in mind when we start discussing the rest of it. Another observation that RPs have appointed entities. Now, entities are firms, LLPs, could be private limited companies, IPEs, for providing support services. Support services including infrastructure, manpower, and advisory services. The paper says that the scope of work for such engagement is broad-based. It can't be, or in most cases, it is in such a manner that one cannot really assign accountability or have performance metrics in how that such support service is actually been performed. The RPs seem to justify the need based on the large size of the particular assignment that they are carrying on, or the complexity involved in that particular assignment. Now, this is a comment which now the board is making, that in case of advisory firms, where such advisory firms are appointed, other than IPEs, okay, throughout the paper, the IPEs are considered to be allowed entities. But other than IPEs, any advisory firm, when they are appointed, the scope of their role is unclear. I mean, this is the comment that the board is making as to what advice the RP seeks and requires. Because as per the board, the code and regulations are very clear and provide ample clarity and guidance. Now, this is the viewpoint of that the board has expressed to the paper. They are raising concerns that especially when such services are engaged at large payments, there are examples of that having happened, many of them. And a specific concern is also that when an RP is appointing another IP in the capacity of a IP as a process advisor, then question marks are raised on the competence of the RP himself or herself. That why do you need one more IP to tell you what IBC is about? Okay. There are concerns relating to outsourcing of duties. This has happened prior to this. But yes, when you appoint a firm whose activities are not very clearly demarcated, then one doesn't know where the RP's duty is ending and where that firm is taking over. In almost all cases, when such an appointment is made separately, then even the fee is paid separately. So this is a cost factor which is coming in, that an additional cost is incurred primarily to do duties which the RP is supposed to do and should have factored in when the RP has made his own or whatever, entered into that contract or bid for his fee structure. And in many cases, this part, the amount paid to such an advisory firm is exorbitant. Okay, there's a particular reference of that having been 19 times that which was being paid to the RP. A concern has also been raised about a large number of people being engaged through such support services or advisory firms, most of whom may not be bound by the confidentiality clauses that are there, or even if they have been administered such a thing, the difficulty of ensuring that the confidentiality is maintained. So there is the potential for breach. A quotation, a particular para has been picked up from the, I think it's the Videocon order, where the bench made this observation that there are too many people in a COC meeting who apparently are advisors or assistants or support staff of the RP. In one particular example, it was that the number of members from the creditor side was about 20, whereas from RP side was 28, more than the creditor. So this leads to questions whether the RP is fully prepared to do his job, or is it just being done to take away more money? In a way, they have said, yes, this is not fully above board, so to say. The board has made a comment in this paper that based on market practice and whatever the provisions are, A very rigid restriction on the purpose and scope of appointment of professional may not be desirable or even feasible, but still something needs to be done. So what is being talked of is a need to account for the misuse of discretion. Now, when they are saying misuse of discretion, they are saying that this has been observed, that IPs have misused the discretion available to them to appoint professionals, one when there is no need or no justifiable need, and two at a cost which is significantly high and not justified by the supposed benefit being derived from that. Then the paper comes into some of the DC orders, that is this disciplinary committee orders. One of the things that's been mentioned is that an LLP does not fall within the definition of the term professional. What the board is trying to say is that professional here, when used in the code, whether in the IB code itself or in the regulation, means regulated professional. And I think they have made this clear in the regulations that have been made for the personal insolvency part of it, that the words have now been used as regulated professional. So the idea is, the thought process behind it is that while anybody can be appointed, that is not what the code has envisaged. And to ensure that both there is transparency and accountability, the preference should be to appoint regulated professionals. That means those regulated by a statutory regulator. Then again, the cost factor, that all additional appointments add to the cost and burden an already overburdened corporate debtor. Okay. So now that is the background. So we will now straight away come to the actual proposed regulation. Okay, this is the text, whatever. The first part of it says the interim resolution professional or the RP, as the case may be, shall, okay, this is important, the word shall, it's mandatory, perform the following actions before making an appointment under this regulation. The word is shall and before. Okay. Earlier regime, what generally used to happen is that if the RP appoints a professional, or a firm, for that matter, any firm, would normally take a financial approval of the COC, maybe before, maybe after. But now it's being put into practice. The proposed regulation says it shall be before. Okay. Now, what are those actions? Subclause A, the request for appointment of professionals must be laid before the COC for ratification. The wording is a bit of a problem in terms of drafting, because if it is before, then the word ratification doesn't go with before. It should be approval. But yes, possibly what is being thought of is that there is an IRP stage when there is no COC. So I think the wording is trying to cover both phases, the IRP phase when the COC does not exist, and later on the RP phase. So, okay, that apart, we know what the intent is, that basically it should be prior approval. IRP position is different. Okay, such request for appointment must be accompanied by certain things. What? A statement in writing, providing the reason and justification for the appointment by way of a cost benefit analysis. The scope of work which is assigned, that means now the scope has to be very clearly defined, such the absence of such services in the corporate data. That means whatever that I as an RP am asking for, I need to appoint this professional to do this job, this is the reason, this is justification, etc. And I also have to say that in my assignment, this service or this type of expertise or this type of skill is not available. Okay. Then the manner of selection. Now this was not there earlier. Earlier, effectively, as far as the code stood, The RP could appoint anybody. All he had to do was take the approval of the COC for the financial part. So within that budget, whatever the COC sanctions, you can go ahead and appoint anybody. But now, no. Now even the manner of selection shall be part of this, the justification and ratification. And the reasonableness of cost. Now this is, of course, cost benefit analysis also talks about it, but both are included. I'll just run through the entire regulation. It's not much. There's just one more clause, and then we'll come back for discussion. The last subclause C, the request must also be accompanied by a declaration by the IP that one, he has exercised reasonable due diligence before proposing such appointment. Then the appointment is not of a related party. Okay, this sort of was always there, but here it says not just, okay, related party, but I am disclosing, not good enough. It says the appointment is not of a related party. Okay. That he has obtained an undertaking that the same professional, now this is important, this is new, whoever is proposed to be appointed will not associate himself in any way with other stakeholders involved in the process. And finally, that requisite disclosures have been made regarding such appointments. Okay. So these are the things. Now the floor is open. We will follow the same usual practice. Just use the raise hand symbol and anybody can come in. Okay.
The raise hand symbol is not there.
Okay, it is there, but I think you have to go against your name and do it. Fine, fair enough. Yeah. Anyway, since you came first, Bhuvneshwari ji, just hold on. Mr. Tarakan, go ahead.
Sir, it seems a little too restrictive because the first 30 days of an IRP before formation of COC is very important. He has to take a lot of things into consideration. Even an understanding of the CD itself will be very limited. Why too much restrictive on this? Is it not very restrictive?
That's the whole idea. To make it restrictive.
So, can I come in? This is Shantanu.
One second. Shantanu, 1 second. Bhuvneshwari had raised her hand earlier. Ma'am, go ahead.
Good evening, everybody. Sir, actually, whether this new proposed regulation, whether it comes or not, in the genuine cases where we appoint professionals, means genuine IPs, appoint professionals, this is how we do it. Whether by the new regulation, nothing is going to change for us. The problem is basically with respect to certain IPs who just act as rubber stamp for certain big firms, and the big firms generally they dictate the terms and IP is just signing on the dotted lines, that's all. It is to take care of those appointments this regulation is being proposed. I think it's a open secret for everyone, what's happening with bigger firms and bigger cases, how it is being bagged and how IPs are being appointed. That is why the firm's fees or the advisors fees are 10 times more than the professional's fee, IP's fee. I think, it's a welcome step. And anyway, it doesn't change anything for us as IPs. So,
Thank you. Thank you.
Okay.
Shantanu ji.
Yeah, I beg to differ a bit here. So, as I see this particular regulation, the problem will arise in the IRP period. Now, as a IRP, you are not only supposed to do the claim checking. You are also, and form the COC, you are also supposed to take control and custody of the corporate debtors, assets, and things like that. So there are several other things that you need to do, for which you need to appoint certain professionals. Now, what my experience says, or I have seen this, that in many cases, post facto, getting approval of the COC, there is a problem. COC may say this fellow's cost is high, this is, and entirely it may not get approved. Now, if it is not getting approved entirely, then what happens to these professionals whom you have appointed? Now, is the IP supposed to pay from his own pocket? I suppose the intent of the regulator will not be that. So I feel if this regulation must be done, then the IRP responsibilities should be only confined to verification and collation of claim and formation of COC. And once the COC is formed, in the first meeting of the COC, along with the IRP proposing his own name to be confirmed as RP, all these rationale of all such professional appointments, why they are required and what is this thing, should be tabled, approved by the COC, and then only the further process should continue. Otherwise, the risk return matrix for an IRP is getting very skewed against the IRP. So that's my take on this. I'm not saying this should not be done. I am all for transparency, all for, I agree to an extent that yes, there is a process which needs to be followed for appointment of professionals. We usually take 3 quotes and things like that and, give the profile. But then if there are certain things that I need to immediately do during the IRP period, and I'm not very certain as to who is going to pay the fee, nobody is going to work for me. I cannot tell them that your fees are subject to approval of COC. So either you remove the taking over custody and control from the IRP period, and keep it for 1 month later.
Right.
And that is my suggestion.
Yeah. Thank you. Bhuvneshwari, go ahead.
Yeah, sir, what practically happens is that with respect to the financial creditors, before we give consent, the bank is asking for a quotation. When the quotation does not only includes the IRP fee, RP fee, also the other professionals, all other costs, what we are supposed to incur during the IRP fee and also the RP fee. That's how the quotation is done. For example, if you look at State Bank of India and any other bank, this is how they do it. So that is already visualized and accordingly we make the appointment. So during the IRP period, even if you do it as per the quotation what we submitted and got it approved, if we make appointment, tomorrow getting it rectified is not an issue at all. Only maybe in the case of operational creditors or in some other appointments where the bank is likely to change the RP from the IRP, maybe it's an issue. Otherwise, in a normal case, bank case, it is already taken into account. That's how the appointment is made.
So here we are talking about the regulation as a whole, and we are not talking about only IRP being appointed by the bank. There are a host of IRPs who are appointed by the NCLT also, and the operational creditor also. They are also part of our fraternity. Yeah. So we need to, even when we are discussing regulation, we need to even look at their interests. I almost exclusively work for banks. I have handled 18 cases so far. Okay. And but however, there is a one-off stray case comes from NCLT. There you generally tend to face a lot of problems. The operational creditor who files the application, at times looking at the implication doesn't even file his own claim. So, and you're left holding the baby. And I'm sure there is a host of other members of our fraternity who will be basically depending on the NCLTs to give them cases, and we need to, when we are talking about regulation, there is no differentiation of regulation between someone who is working for the banks, who are being nominated by the banks, and someone who is working for the, operational creditor. So the regulation will be same for all. So the regulation, I feel this is a case of kind of over-regulation. This is my personal view. This is.
Yes. Anybody else?
But Shantanu, there is a point in what Bhuvaneshwari was telling, that it is to prevent big IP firms who are actually, say, she was telling that advisors are taking big money than what is IPs. There is a point in what she is also telling.
Sir, what I
No, for this the solution
then
should come from
IBBI should,
Shantanu only.
One
who is
second.
proposing.
Anybody, please raise your hand so that you are recognized, or at least switch on your video.
so may I just
please avoid
complete my point?
crosstalk.
May I complete my point?
Yeah, let
So
Shantanu complete. Next,
in
whoever
which
is.
case IBBI should call a spade and say that certain, like they recognize what is called an IPE, right? So they should say very clearly, other firms, let's say the big 4 or big 5 who have no IPE, should not take up the job unless and until they have a IPE. You cannot be very circumspect with regulation. You are a regulator. You simply say that you cannot be, if you are not an IPE, you cannot support. So let the persons who are working for this big firm become their whatever partner, director, let them form an IPE and let them go ahead.
Okay. Mr. Rajiv Chopra?
Yeah.
Yes, you see, I was listening to what Mr. Shantanu was saying, but I could not understand that how come it is in the direction of controlling the cost, or the way it has been proposed that it should be approved by the COC. If we don't get it approved by COC, then how it's going to help? And if at all, when the banks are already doing it, that during the IRP process, whatever cost or whatever fee has been agreed, that includes everything. And in this case, the way you are proposing that if some proposal comes from NCLT, that should go uncontrolled. This is what you are trying to suggest, or what is the solution you propose for this?
What I proposed was very simple. I simply proposed that during the IRP period, when there is no COC, at that point of time, the duty of the IRP should be confined to collation and verification of claims and forming the COC and inviting all these professionals, doing this exercise of which are the professionals to be appointed, the rationale, all these things, presenting them before the first COC for approval. And after the COC approves all of this, then go ahead with the CIRP, rest of the CIRP process. That is my simple, that is my
yeah. Please do not
wish list. That is my wish list.
No crosstalk, please.
Yeah, my only submission is, supposing you have hired some professional. I am not talking about out of the, there have been cases where a particular professional has charged a fee which was actually approved by the COC or at the time of his appointment. And there are cases when, due to certain unforeseen circumstances, the CIRP dragged on for a longer period of time, or some litigation, things got stuck in the litigation. And then the COC went back and said, boss, I can't pay you this much fee. So these kind of cases also crop up today.
Okay. Let us not get into exceptions. Shantanu. Okay, yes. Fine. Mr. Arumugam.
Yes, sir.
Go ahead.
Sir, I am fully agree with madam, because there is already some of the meetings it was complained that it's totally monopolized. Now the appointment of RP is monopolized by a few IPE who is having more connection with the banks. So this may be the effect. So for the people who are having even there are a lot of people who is not even get a single assignments because of the they are not acquainted with the top bosses in the banks. So the madam is perfectly correct. It may affect only the big companies, these regulations. And there is a general trend that whenever IP is there, if they are appointing a IPE, normally the fees for the IP will pay to the IP will be only 15%. 85% would be taken away by the IPE. So it may help to some sort of controlling the monopolization of IP. Thank you.
Yeah, thank you. Okay, just before I recognize the next participant, let us restrict ourselves to the impact of the regulation on us as IPs, and not get into the realm of speculation as to who is making how much money and all that. We know, but this is not the forum for that. So let us avoid that. Mr. Sivaraman.
The simple point is, what is the most important things which is to be done during the IRP period is appointment of valuers and forensic audit. These are the two important professionals who are supposed to be appointed in order to start the process. And that is within the period of say 45 days or 50 days, whatever the time period is. And that is the first agenda point which will be there in the first COC. With regard to the other things which are to be there, it will take place on its own. For example, if there is a company which is running, for example, and there are technical consultants, can you just change the name of the consultant who is working in that company? Because the IRP doesn't know much about the operations, right? He must have technical consultants, right, who are running the company. And for that, if the ratifications are required, then it goes for a reappointment of those professionals once again.
Mr. Ramana Kumar.
So that is what is the point. The two points which an IRP should do is only valuers and forensic audit. The other things have to go in its stream, and which is to be ratified by the COC.
Yeah. Mr. Ramana Kumar.
Yes, sir. Good evening to all. As an IRP, I have a few issues which I would like resolved in this meeting, or at least some suggestions. The first is, in the first COC, invariably the bank will change the IRP in case it is a section 9 or a section 10 application, and this alteration of the RP or the appointment of the new RP by the first COC takes effect only after the order of the adjudicating authority. That order of the adjudicating authority is not within a reasonable time limit now. In fact, in one of the cases, I filed the change for the RP. I was the IRP, I changed for the RP in January. Even now, not a single hearing has happened. In these matters, the bank or the financial creditors who are altering the RP are not taking any efforts to make the fees for the deemed RP, who is the IRP and who still is the deemed RP.
Yeah. Okay, Mr.
This is the first issue I have, sir. The second issue
okay.
I have.
One second. Let me intervene.
Yeah.
That is not the agenda today.
Okay.
So that's a different issue, NCLT delays and all that. So let us stick to what is the agenda. That is the proposed regulation.
Yeah, limit to the discussion period.
Okay, sir. Okay, sir. Where I am appointing professionals, say valuers, as an IRP, I am appointing the valuers, but there is a proposal to change the RP. Both the CD as well as the FCs are not cooperating with those professionals for the valuation. I have this issue. I want your opinion.
Right. Thank you. Mr. Kasodekar.
Sir, I have only one point. I'm not against any approvals or anything like this. But the question is that there has to be some regulation where the COC should give the reasoning for accepting or not accepting the things, whatever it is. Because anything which is placed before the COC, it depends on the constitution of the COC. They can create a lot of hurdles or sabotage the procedure at itself. So that's why the COC also, when we are giving the authority to COC, the COC should have some restrictions or give some explanations while accepting or rejecting. Accepting doesn't matter, but rejecting, because see, our IP is under the pressure to comply with everything. Why not the other stakeholders involved in the process?
Very fair point. Very fair point.
Thank you, but again, not on the agenda. Please stick to the agenda.
Sir, yes, because we are giving them authority here. We are giving them authority here.
Okay. Firstly, just to clarify, okay, I'm not disputing or arguing. It is only an expansion of what was implied is now being made explicit. Even earlier, without the financial approval of the COC, no appointment was anyway valid. Okay, जिसके हाथ में purse string है, I mean they control it. That was always there. Now the procedure has been made a bit more elaborate. So that is one. Second, as far as the conduct of the COC and how they should be guided, controlled, etc., there is a separate subject which is under discussion, including in the parliamentary committee on finance, where they also propose that COC should have a code of conduct. I think that a separate work is going on there, and I'm sure something from there will emanate. So today, let us restrict only to this part and not get diverted, because we have limited time. 5 o'clock we are closing. Okay. Ms. Reshma Mittal. Yes,
Sir,
you wanted to say something?
Yes, my comment is regarding this regulation, sub-regulation 5, opening para and subclause A are contradictory, because it says that, and this would be confusing for us, because it says that following actions before making an appointment under this regulation, the request for appointment of professional must be laid before the COC for ratification. So they are using the word ratification, which is taken after the appointment of the professionals.
Yeah,
And
I think I mentioned that when I was presenting it, I mentioned it. Yeah.
We are using the word before. So necessary corrections are required in this para.
Yeah. Thank you. Rohit ji, go ahead. Unmute kariye aap.
Sir, what I understand is that it says that CD need not have the relevant professionals on the board. Now, this allows only for the appointment when such a professional which is required is not there on the board of the company. Now, if the person is not willing to go ahead, the company is having the professionals, but they are not cooperative. That particular portion is a silent in these provisions. Second thing is that the efficiency vis-a-vis the cost, both are important. Now, how to tackle that through the this regulation when we are proposing, when we are discussing.
Right. Thank you. Yes. Anybody else wants to say anything? Yeah, Mr. Anil Singh Patwal.
सर ये अभी जो रेगुलेशन है जिसमें अभी जो बात कर रहे हैं आप भी कि भाई जो प्रॉब्लम है थोड़ा रेगुलेशन में, तो बेटर यही होगा कि पहले इसको ठीक करवाने फिर डिस्कस कर लें।
भाई हमारे हाथ में नहीं है ठीक करवाना, हमें खाली अपना कमेंट भेजना है।
नहीं कमेंट तो भेजना, तो कमेंट तो कभी भेजोगे ना आप कि भाई देयर इज अ प्रॉब्लम इन दिस एंड देयर इज नो एक्सप्लेनेशन देयर।
नो दैट इज नो, इफ यू आर टॉकिंग अबाउट द वर्ड रैटिफिकेशन, उसकी बात कर रहे हैं।
रेटिफिकेशन बिफोर की बात कर रहा हूँ ना।
हाँ तो ओके, देयर इज अ कंफ्यूजन दैट आई हैव while presenting it, I had said it seems to be contradictory because before and ratification साथ नहीं होता, but
you can ask for statutory explanation.
No, we don't ask IBBI for explanation. I think you're a bit confused here. We send a suggestion or a clarification or a comment.
Sir, you are not getting my point.
I am getting your point completely, sir. IBBI को हम explanation नहीं मांग सकते. They don't report to us, we report to them.
नहीं स्टैट्यूटरी इंटरप्रिटेशन की बात कर रहा हूँ सर मैं तो।
वो तो हम कमेंट भेजेंगे ना, वो तो नोट कर चुके हैं, वो तो कर चुके हैं। That part we have noted. That
it should be statutory intervention should be there. If there is some ambiguity and understanding is there, that is the duty of the IBBI to give us the interpretation. What is the problem?
This is not yet a regulation. It is a draft. So draft में जो गलतियां हैं, they have asked for comments.
हाँ तो after that, sir, after that the deliberation will be changed, na? So then we will sit. They will change something and they will come there. They will sit again and discussing this point again.
Yeah. Okay. Just to clarify again, IBBI has not asked for this roundtable to be held. This is the initiative of the IPA to provide a common platform. What the board has asked is every individual IP to go log in on their website and give whatever comment they want. वो आज भी आपके पास option available है, ठीक है?
Sir, we have to be raise our voice that if there is some difficulty facing by the IP to just manage the process
आपने एक ही पॉइंट अभी 2 मिनट में एक ही बोल रहे हैं, हम बोल रहे हैं नोट कर चुके हैं, तो आप बोलना क्या चाहते हैं? नोटिंग हो चुका है कि हाँ ये प्रॉब्लम है, तो है, तो 5 बार बोलने से तो प्रॉब्लम 5 गुना नहीं होगा ना, वो एक ही प्रॉब्लम है, लिखा है, एकदम बिगिनिंग में बोल दिया है। मैडम भुवनेश्वरी, you want to say something?
Yes, sir. Sir, my opinion is that yes, to control the bigger firms and all that, this proposal is made. But at the same time, all these appointments and the cost, advisory services, everything is with the approval of the financial creditors on day one. That's how they are also approving such a big fee. In our cases and all, even 500 rupees things are being questioned by the same financial creditors, but such amounts are being approved.
Don't deviate from the topic.
Sir, my question is
that is our pain point. We all know that.
Just 1 second, sir. Yeah, I understand. Now, when the board is making suggestions that the scope of the work, cost benefit analysis, scope of work, manner of selection, all those things, documentally, everybody, the same organizations will bring in, on paper and close the matter. That's what is going to happen. Finally,
ma'am, I think in every aspect of life, as long as humans have been around for the last 30,000 years, this is true. और ये रहेगा, जो बड़े हैं, the big, it is like there is a saying that where does a gorilla sleep? 500 pounds, wherever it wants to. तो ऐसा है. Bigger has its advantage in every walk of life. Somebody tomorrow can come up and say, ma'am has got 20 years experience or 25 years and says she knows everybody, she gets the assignment, I am just fresh, I don't get it. तो आप क्या बोलेंगे? बोलेंगे I struggled, you also struggle, यही बोलेंगे ना?
But what I'm saying is the bigger assignments many of us don't get, it goes to few organizations only.
Not the subject. Let us not stray from the subject. Subject is, does it impact us the way it is? That's all. Utna pe karenge. We have those pain points. We have been having it for 5 years. Some people will say it is pain for you. So what? There are people with 20 assignments. There are people with none. Hey, fact of life. Life is unfair. Mr. Shivaswamy.
Yes, sir. Good morning. Good afternoon, sir. Thanks for giving a chance. What I feel is, sir, regulations with all those things which are in place or which are going to be recommended, those have, okay, that will be there. But leaving everything at the decision of the COC or to their wisdom, it really defeats the purpose, because COC does not gain anything by appointing 10 professionals or recommending 15 professionals and all that. They want the work to be done. You are saying that commercial, as far as commercial wisdom is concerned, COC's commercial wisdom is granted even by NCLT. But this is not a question of commercial wisdom, it's a question of administrative convenience, for which they are actually duty bound to provide. He will say, I will not provide any professional to you. You appoint a valuer for 10,000 rupees and other person for 5,000 rupees, and you take a salary after 15,000 rupees. Now, with that kind of attitude, I don't think all these things are going to have any effect on the COC, at least.
Okay.
COC
will have it. Right. Yeah.
COC, let me complete my statement. there is a regulation is there on a liquidation on 21 regulation where you have to, there it is clearly stipulated that their COC is or during liquidation they have to pay the fees as laid down. Then after that they say it is left to the decision of COC. COC says I will pay you 1 lakh rupees fees for 1 year working as a donkey. And then they say it is approved because COC is the COC wisdom, we approved it. You cannot question it. No, if you are facing so much of faith is there on COC, then let them solve that without themselves. Why they want IPs there? IPs are not there as their domestic servants.
Right. Okay. Thank you. Ms. Reshma Mittal.
Yeah.
Sir, I want to say that if the IP is partner in an IPE, in that case, how this we have to deal with this manner of selection?
Okay. Good question. Now, let me take you to Regulation 27, Sub-Regulation 3, and I'm going to read it. Okay. And okay. The IRP or the RP, as the case may be, shall appoint a professional under this regulation on an arm's length basis, following an objective and transparent process. So what is being added today is just a clarification of sub-regulation 3. It was already there. Now it is being split up into parts. Okay.
Yes.
Provided that the following person shall not be appointed, namely a relative of the RP. RP includes IRP, a related party of the CD, an auditor of the CD at any time during the previous 5 years, and fourth, D, a partner or director of the IPE of which the RP is a partner or director. Answer?
No, partners. It is talking about the partners
Partner
of the
or director of the IPE cannot be appointed as a professional during this process.
Sir. Right. But I am talking about if the IP appoints an IPE for the
support services is allowed. See, if I would request you to read this discussion paper again. They have clearly mentioned IPEs are exempt because they are treated as regulated by IBBI itself. Okay, so they are being exempt, but they cannot do jobs which are beyond their remit. What an IPE can do is also defined.
Okay.
Okay, so within that, I mean, an IPE cannot, for example, be your legal representative.
Sorry?
They cannot become your lawyer.
Okay,
IPE is only for support service. Okay.
Support services, right? But IPE provides the IPE itself is having some internal team of the legal professionals and networking with the legal professional practicing.
That's different. Networking is always recommendatory, is not part, and as long as they don't charge for it separately, it is part of the package. So आपको एक पे एक free मिल रहा है तो ले लीजिए. Nobody stops you. Yeah, Mr. Devarakonda.
Sir, one small whatever we are seeing this recommendations, the proposal that has come, it is putting big and small cases in one group only. That's not correct, because even if one big IRP or an IP, some the units think of our Mr. Sahu himself is making an IP for one company. If it's a large company like SRC or something, he can't do, because from day one he will need the support of some big firm or even if an IP or whatever it is. So it's not true to say that unnecessarily they're appointing and all that. No, see, even if you're a big individual, you have done 100 cases, you have a lot of experience, unless you're supported, especially in case of a large assignment, unless you're supported by a big team, it doesn't happen. So I'm not talking of cases where NCLT appoints, nobody is appointed, there's no claim. So ideally, this proposal should have been divided into two parts. One, large. Okay, what is large, what is complicated, that can be defined separately. But what is large, they should permit. What is not large, then maybe they could have done a separate thing. That's what I think.
No, the process is size. What is being proposed, the regulation, has nothing to do with the size or complexity of the operation. In fact, it is very, very, very what you call wide in scope and discretion, that you decide that you need, you go to the COC, you convince them, you go ahead and do it. They are not saying don't. They are not saying how much to be paid. They are not saying it cannot be. They are saying COC should now become a part of the process. That's it, nothing more. It's like the board of directors becoming part of the process, CEO versus board. We see it all. I mean, no company allows unfettered, power to its CEO, and when they do it, we know what happens, right? We have seen ILFS, we have seen NES. Okay, let's not take names, but we have seen what happens when CEOs get total power. Yeah. Anybody else?
Even before COC is also a part of it because they have to approve it. So even without framing this regulation or the proposed regulation, COC was very much part of it because unless it is approved, he cannot move ahead.
Absolutely. Financial power was always with them. Without money, you can't do anything anyways.
Right, sir. Yeah.
See, what is being done, really speaking, as I said, it is not new. It is expanding sub-regulation 3 and putting in place certain structure of how you go about, picked up from best practice. As Bhuvneshwari very rightly mentioned, this is what all good RPs are doing anyway. So they have just picked it up and said, now everybody should follow this.
If I view positively, can I say that it makes obligatory on the part of COC to approve it?
No, it makes it obligatory on the part of COC to consider it. They may not approve, they may reject.
Okay, but it is obligatory to consider it.
Absolutely, obligatory.
That is positive, I would say.
Yes, yes. It will be an agenda item. It will be minuted. It will be recorded. And if the RP is aggrieved, there is always NCLT. If it prevents the RP from doing his job mandated as by the court, nothing prevents the RP from going to NCLT.
Yeah, that's right, sir. I agree.
Yeah. Yes. Any other comment? Okay. So it's not very complex. Just to reiterate, it is just an expansion of sub-regulation 3. Now it is just putting in place specific steps and the timing in which they will be done. Okay. So largely it will be pre-approval. In the case of the IRP stage, it is ratification. Again, not different from what it was as of now. But the COC today in this regime, now the COC has slightly expanded role. And they won't just look into the cost part of it, but they will have to look into the need part of it. So one can look at it as a governance enhancement measure, corporate governance. So it's from that angle. Mr. Tarakat.
Yeah, sir, if I say that it is restrictive on the part of their IRP, is it correct?
Not really. There is no change, as I said. Now, instead of the IRP stage, there is no COC. So IRP has that power under Section 20 already. Okay. Even earlier, when they were doing any appointment of whatever type of services, professionals, etc., they had to get it ratified from the COC. Otherwise, paisa kaun dega?
Okay, sir. Okay.
So nothing, no change except that it is now written down. What was understood and implied has become explicit with specific sequence in which an activity is to be done. Rohitji.
Yes, sir. So if the request is made for a professional, can COC reject it? Ratification is on the cost side, but whether COC can reject that this professional is not required.
Yeah, absolutely. Now that is the power that is given to the COC now. See, earlier, if they were not ratifying the cost, automatically it was rejection. It was deemed rejection. Now, because it will be discussed, it will be minuted, okay, including reasoning, whatever. So, in a way, the RP has, actually the RP's hands have been strengthened in this. I would look at it positively and say, now I can record why the COC says so, because I will ask them, why are you saying no? Suppose they don't want to say anything. No, 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 no. I will write, no, no, they didn't say anything. They did not give a reason. Not giving a reason is looked at as negatively by all courts in the country.
That's right, sir. I fully agree.
So it actually strengthens your hand.
Okay, it strengthens the requirements. If professionals are required, one can definitely insist for that.
Yeah, absolutely.
Now
Except that instead of making it like in some cases, okay, as I said, what has been done here, regulation 27, sub-regulation 5 is just an enumeration of the existing best practice in the domain. Okay, many RPs are following this largely. Now they are just formalizing that process and saying, okay, these things also please record it. One is the statement in writing, which provides reason and justification. It helps you because then you are safe also. Look at it from that angle. Once my thoughts are clarified on paper, I know exactly what I want.
Correct.
We do it in a companies when we are like senior managers or whatever. We have to put these things in writing. We do it all the time.
Yeah, it is a documentation process.
Yeah. So it's good for everybody concerned. Himanshuji.
Yeah, good evening, Ganti ji. See, what I understand from our discussion and from the paper that suppose I am IP and I am also having a IP entity, then the IP, I can appoint an IP entity for support services, not the legal and other services or advisory services. And whatever the amount is to be paid to IP entities need to be approved by the COC. Though I may appoint arbitrarily in the beginning, but if the COC do not approve it, then my situation will be little odd that my entity may not get anything. Can you comment on that, sir?
Yeah, well, part of the risk you have to say. Okay, if you go back the last 5 years, how things have evolved. In the initial years, this was really a big problem because there was no money at all. But today, what is happening is that NCLTs typically are asking anywhere between 2 lakhs to 5 lakhs to be given to the IRP for expenses. Okay, so that the applicant is paying. And the regulation says if the COC doesn't approve it, the applicant has to bear it. So the onus has now clearly shifted on the applicant. Don't do frivolous litigation. Okay, if you cannot afford it, don't fight. Even if you do not, even like an OC, somebody mentioned that you do not actually recommend an RP, it is IRP is appointed from the list. But the order now carries a requirement that the applicant shall deposit a certain sum of money. The minimum is 2 lakhs now.
Right.
So you are covered. I mean, your expenses are covered. Whether you deserve more or not, then
Yeah, I can understand. That's a very relative term. What is reasonable is absolutely relative terms, and that's the creating some more issues and problem also.
Yes, true. Shamalji. Shamalji, we cannot hear you. Only static. Still no. Audio is a problem. Okay. Mr. Devarkonda, go ahead.
In the previous example, supposing a IRP is one part of an IP entity, okay, and then he wants to appoint that entity as from the day one, even the IRP stage itself, because normally large cases, unless they support services, you can't. Then does it mean that he should get quotation from two, three IP entities, like valuation? I get 2, 3 quotations, or advocates will get 2, 3 inquiries. So does it mean that apart from my own IP?
I got your. Okay.
Can you?
The IPE is treated a bit differently than the rest of the professions. Number one. Number two, the regulation does not say you have to get so many quotations. It says you satisfy the COC. That's it. It can be with one quotation, it need not be. Now, the next point, a large entity, CIRP, IRP being appointed from the panel, very unlikely. It will be a Section 7 application, most likely, which means that this would have been factored in when they had asked for the bids from the IPs. So We are talking of theoretical possibilities. Frankly speaking, they are not as many. In the OC, in the Section 9 application, there were, it used to be very bad earlier. Things have improved. Now the minimum expenses are being covered for the 1 month. Expenses, not fee, expense. Okay. Whatever, so that the IP is not out of pocket. But sometimes you get a bad call. See, look at it. What are we? We are getting into an insolvency situation where people have not paid for services availed. So हमारे साथ भी वो हो सकता है ना?
It's been happening anyways.
It will happen. So why do we no, we are not immune from the economic system. We are part of it.
True. A CDR, a promoter who cheated crores to banks, for him lakhs.
Not just cheating. Let us say genuine. Okay, ho sakta
Genuine.
Can happen. Okay, Mr. Vora.
Yeah. So it says about the cost benefit analysis. Now, as far as the cost benefit analysis is concerned, it doesn't mean only the comparisons between two professionals, but even with the one professionals, after appointing that them as a professional, what additional benefits it's going to bring. So it's not, I understand this is in addition to the value of
cost benefit analysis has nothing to do with comparative quotation.
Yes, correct.
Very right. It has, whatever be the cost, what is the benefit derived?
Correct.
It has to be more. And if two competing quotations, one is lower and they give the same benefit, then the cost benefit ratio is higher in that case. But in both cases, there has to be a benefit. It can't be only cost. खर्चा करो और कुछ नहीं मिलेगा.
खर्चा करो और
yeah. Okay. Mr. Shamal's query is audio is a problem. He's saying, is quantification of benefit possible in case of professional services? It has to be done in every corporate. How do you do it? That is the innovation and creativity of the person. And I'm sure most IPs, if not all, know how this is to be done. And does this proposed regulation exclude appointment of advocate and accountant? No. In fact, they are the ones that are actually included. The rest are others are excluded. Right. So we are at 4:40. I think we have gone on for 1 hour 10 minutes. Already exceeded our allotted time. So thank you from my side to everybody.
Sir, I think,
yes.
Sir, I think legal professionals are excluded.
No. Professional. No. Kuch nahi. It is accountants, lawyers, and other professionals. So other is, what is that other professional? The board is saying those also should be largely either regulated professionals or of a category which is necessary for running of the business of the city. Because see, if you are talking of, let us say, a very specific category of engineers, they may not be regulated, but that is essential for the business. So that will be. Yeah. Right.
Sir, whether it is necessary or not, is it left to the wisdom of the COC?
Yes. Ultimate. See, it is a two people. Okay, I am proposing. You as the COC have to accept. Now it is also my competence to be able to put it across properly to you, na?
That's right. That's agreed. Fully agreed.
Ravi sir, am I audible to you? Can I raise my query?
Yes, please do. Yes.
Sir, actually, it is a bit related and a bit different as well. There is one IPE, that is insolvency professional entity, in which from which one of the resolution professional has been appointed as an RP to a CD. Right now, the CIRP is over, company is under liquidation, that RP is no more a liquidator in that company. Liquidator is different. Now, another partner from that IPE wants to give his expression of interest in case of PG to CD case under section 95. So will it be account for a conflict of interest or not, sir? This is my small query.
So PG to CD, another partner, will that be conflict of interest? On the face of it, yes, because it is challengeable. It is not explicitly excluded because only the RP is prohibited. RP's partner is not explicitly prohibited, but be sure that the guarantor is going to challenge it.
Sir, but the thing is that the RP is no more related to the CD now in any manner.
That's
the company
okay.
is
That's okay. No. Once you are there, you are privy to that information also. It's equal. See, there are certain regimes where RPs are allowed to be both. This is not a matter of what is right or wrong. It is a matter of allowed or not allowed. Simple. उसके logic हम नहीं जाएंगे. Okay. The practice of each country might differ.
Okay. Sir, in regulation 4, it has been specifically specified that the insolvency professional entity of which he is a partner or director or any other partner or director of such IPE does not represent any party in the resolution process. So this resolution process.
हो गया. Okay. I'm not saying no. See, it is not disallowed. Okay. But it doesn't fall within the governance part of it, which is not mandatory, it is desirable.
Okay, sir.
So it's subject to challenge, okay? And the NCLT may accept the version of the guarantor and say, oh, this man was involved, I don't want him, or is it? They might say, okay, IPs ki to kami nahi hai, let us have somebody else.
Okay, sir. Thank you. Thank you for your kind guidance. Got it,
Right.
sir.
Right.
We need to give
Nitin?
justification, else it will be acceptable. Like we need to give the justification for that. Okay, agreed.
Yeah,
thank
you need to defend yourself if questioned. But the idea would be better to be safe and not get into it.
Okay, okay. Thank you. Thank you, sir.
Nitin, are you there?
Sir.
Yakshuk? Yeah.
Yes, sir.
Yes, we have finished.
Sir, thank you so much for your time and effort for giving us an insightful session. It was indeed a fruitful session, and thanks to all participants for sparing their time and making this discussion successful. Any other participants, if you have any query regarding the subject matter, you may please raise your query, or else we shall conclude the session now.
I think they can send, I'm sure you can send it to the IPA, to their email ID, whatever, if you think of something different, please go ahead and do it. And everybody has the right to go on to the IBBI platform and also put in your own comments or whatever you want to say. Okay.
Yeah, thank you so much, sir. Thank you so much to all participants.